I'm Drew Stevenson, and this is a lecture about the famous case Morrison v. Olson, a U.S. Supreme Court case from 1988. And this is about what we call inferior officers. That's a phrase from the Constitution, and the president's authority or power to appoint and remove these individuals. And now a quick word for my students. I cover this case in two of the courses I teach regularly, administrative law and statutory interpretation and regulation, or Leg-Reg. It's a very famous case where the court basically defined these inferior officers for us. That being said, my students should keep in mind that we still have a lot of uncertainty around the edges with the line drawing between principal officers and inferior officers and regular agency employees. We still have cases going to the Supreme Court. We've had some in recent terms, and these are close cases where there's still a lot of uncertainty. So again, we don't have bright line rules here, but we have some general principles so that make some cases predictable and other cases close cases. So let's look at what happens in Morrison v. Olson. This case is a little complicated. There's a lot of drama here and with some pretty well-known public figures. So I'm going to give you the takeaway up front in case you give up on me at some point, because some of the legal issues are a little boring. So this is where the court defined inferior officers for purposes of presidential appointment and removal powers. If you don't get anything else out of the case or this video, it's that Morrison v. Olson is about defining inferior officers. And that matters because if they're inferior officers, then they don't have to be appointed by the president or removable directly by the president. And that in turn matters because if we have a statutory scheme that creates an official that doesn't comport with the constitutional appointments clause or removal clause, then the actions of that official have no legal effect because their position is unconstitutional. But here the court upheld the statute. The statute allowed federal judges or the judicial branch to appoint independent counsels who are removable by the attorney general and only by the attorney general and only for good cause. But in fact, most of these independent counsels were supposed to just leave the position when their investigation concludes. In other words, this isn't a permanent post. They are there to investigate one scandal, and when they wrap up their investigation and write their final report, they're done and need to find a new job, basically. Now, just a quick word of background. Where did this come from? This is a Watergate era statute. So President Nixon, back in Watergate, had a scandal that was about bugging the Democratic convention's headquarters. And then there was a kind of the cover-up itself became a scandal too. And what happened was when different people in the Justice Department or the White House lawyers started investigating it or looking into it, he would fire them. And so in the aftermath of Watergate, Congress, which was controlled by Democrats at the time, decided to pass a statute to make sure that we didn't have this happen again, that if there was ever another scandal with the president or some other White House official, that we could somebody could be appointed to investigate the scandal who the president couldn't just fire. And that's what the independent counsel statute was about. But this case is about the Reagan presidency. So again, another Republican president, a Democrat Congress, and a big scandal. And so let's meet our characters here. Morrison is Alexia Morrison, a lawyer who is the independent counsel. And she was actually appointed to investigate another lawyer in the government, a White House lawyer named Ted Olson, who was accused of lying to Congress under oath during a House committee hearing, and that he refused to turn over documents during a congressional inquiry into a scandal about the EPA Superfund money. Now, just real quickly, Ted Olson was not accused of mishandling the Superfund money or embezzling money. He was just a lawyer who kind of knew what happened and was asked to testify, and basically people thought he had lied. Also, as an aside, what do we mean by Superfund? Some of my students might be unfamiliar with this. We have a number of sites around the country that are sort of massively polluted, like super pollution sites, where toxic waste was dumped in large quantities for years and years and years. And so you end up with a whole tract of land, acres and acres, where the soil is completely poisonous, basically, and needs to be, in some cases, drastic remediation is required of like hauling all of the soil away practically down to the bedrock and replacing and hauling in or trucking in new soil. Well, most landowners don't have the funds to do that. So what would happen is these heavily polluted sites would just stay polluted, and then the pollution continues to spread in the ecosystem for year after year. So what Congress did is they set up this huge fund with billions of dollars in it to come in and do cleanups that no one else would be able to afford for these massive spills or areas. It's usually where dumping was done over a long period of time. And that brings us to the Superfund and this and the misuse of the funds. Now, the court found that the Attorney General, the fact that the Attorney General had removal power over Alexia Morrison, together with the discrete tasks that she was given, she was only investigating this Superfund scandal, and the limited duration of the assignment, all of these implied that the independent counsel was, quote, an inferior officer. And therefore, we didn't trigger the appointments clause requirements that the president would nominate the person for the post. Okay, so who started this whole scandal? Anne Gorsuch did. In 1982, Anne Gorsuch and one of her subordinates at the EPA were accused of mishandling the $1.6 billion toxic waste superfund. Anne Gorsuch was the EPA administrator at the time, and she basically bragged to some friends on one or two occasions that she was withholding disbursements for cleanups in California, specifically, partly to stick it to California. She was a Republican and California is a Democratic state, but also specifically to hurt Jerry Brown's Senate campaign. He was somewhat earlier in his political career at that point, among other things. So word got around, and Congress demanded records from Gorsuch about how these decisions were made, and she refused. And in fact, President Reagan forbid her to cooperate with the investigation or turn over the documents that were subpoenaed by Congress. I'm recording this video at the end of 2020, and some of this should sound strangely familiar to my students. The other thing that should sound familiar is the name Gorsuch, because Anne Gorsuch is Neil Gorsuch's mom. Justice Gorsuch's mom was the person at the center of this scandal because she was the EPA administrator. Okay, back to our case. So Gorsuch has a distinction of being the first agency director in US history to be cited for contempt of Congress because she wouldn't cooperate with their inquiry or investigation into this. And so eventually, another lawyer in the White House basically fessed up or came forward and said that this was all true, that they knew what Gorsuch had done. And so she had to resign. I wouldn't say she resigned in disgrace, because a few months later, Reagan just appointed her to another position in another agency. So Anne Gorsuch was fine. She landed on her feet, but she was out of her job at the EPA. And so the White House basically stopped having to fight her case and dropped the whole thing. And there was no point in fighting it. Well, Congress was still mad, so they summoned Ted Olson. Ted Olson was an assistant attorney general, but he worked in the Office of Legal Counsel in the White House. He's also done some high-profile things since then. And that leads to this case. Olson's testimony about withholding of documents that had been subpoenaed led to an investigation by the House Judiciary Committee, and they eventually produced a report. Basically, everybody thought that Olson had lied under oath to Congress when he testified. And so they investigated it to verify that he did in fact lie and concluded he had given false and misleading testimony before a House subcommittee during the investigation. So the chairman of the Judiciary Committee asked the Attorney General to have an independent counsel appointed. This actually involved some people from the judicial branch to investigate the allegations that Olson had lied. And so that's where Alexia Morrison comes in. She was named independent counsel and given jurisdiction to investigate basically just whether Olson had violated federal law. Olson didn't want to be be investigated or have a subpoena from Morrison. So he basically said the whole act, her whole position is unconstitutional. And so therefore, if he could get the act declared unconstitutional, then Alexia Morrison would have no legal authority to issue the subpoena, and the subpoena could get quashed, basically. That's what he wanted. Now, let's back up a little bit and talk about the Constitution. The Constitution has this phrase, inferior officers. And so principal officers have to be appointed by the president and can be removed directly by the president. They're appointed with Senate confirmation, of course. And in Humphrey's Executor, you may remember the court said that Congress could, for certain officers, require that the president show good cause when removing someone, but that's about it. Otherwise, we don't have any constraints for principal officers in the Constitution. And we're thinking about people that are heads of agencies and members of the president's cabinet and so forth. But then the Constitution says that inferior officers can be appointed either by the president alone or by courts or the heads of other departments. And so who are these people? They're usually mid-level officials or lower-level officials, not just the staff at agency. These are people usually with supervisory roles that exercise some discretion, but they're not the top person in an agency. And in fact, they usually work under the supervision of the people that have to be appointed by the president, the principal officers. So they're an in-between sort of tier of management between the top people, the agency directors or secretary or whatever, and then the regular agency employees and staff. So the court here held that independent counsels are inferior officers. Why? Because Morrison could just be removed by the Attorney General, albeit for cause, but was not otherwise under the supervision of the Attorney General or anyone else. But also the limited scope and duration of the independent counsel's appointment and the removal power led the court to find that she was not a principal officer. She's not in the same category, for example, as Ann Gorsuch, the head of the EPA. By the way, please note that in dicta in this case, the court cautioned that it could imagine some inferior officer appointments that would violate the Constitution because they might cross departmental lines or branches of create interbranch problems, like interbranch appointments. It could create a problem. So that's not the case here in Morrison v. Olson, but they did warn this isn't basically saying that inferior officers could never be unconstitutional just because they're mentioned in the Constitution. We can imagine some hypothetical situations that would be unconstitutional, just for your notes. Now, we have a classic dissenting opinion that's scathing and bombastic from Justice Scalia, and he completely disagrees with the majority. So Justice Scalia argued that First of all, this is a purely executive power. Investigation like this into misconduct is a type of prosecution, and you can't get more executive than enforcing the law, like the prosecutor's office. And for my students, I want you to connect this part of Scalia's dissent with cases like Myers and Humphrey's executor, where the Supreme Court had really focused on the function of the official to decide which branch's function they were kind of doing. Are they doing legislative or executive functions? And Scalia says this really looks executive, and that's so in line with those other cases that were sort of these functionalist cases. Then this should require presidential appointment. He also thought it was really problematic that the president didn't have exclusive control of these investigations. He also predicted accurately that the statute would eventually backfire on the other political party, i.e. the Democrats. So remember, this was created by a Democratic Congress because of the Republican President Nixon, and now it's being used against a Republican President Reagan. But he predicted or foresaw a day when we would have someone like Ken Starr, who was our last independent counsel, doing investigating a scandal with a Democratic president like Bill Clinton. And by the way, after the Ken Starr ordeal and the Monica Lewinsky scandal, the next time the independent counsel statute came up for reauthorization, you might remember these sunset provision statutes come up for reauthorization every few years, both parties decided to let the statute lapse. So we don't even have the statute anymore that's at issue in Morrison v. Olson, just sort of FYI. Okay, I made a diagram. I was hoping to help you kind of keep straight the three type of agency people or personnel that we talk about in these appointment and removal power cases. We have so we have principal officers, and I have a picture here of Ann Gorsuch because as head of the EPA, she definitely counts. So the top person at an agency is a principal officer. Inferior officers are sort of mid-level people, and there's a picture of Alexia Morrison. And then we have our regular agency employees, and so I included a picture of Pam from The Office. Now, keep in mind, not all regular employees are clerical workers and receptionists. This would also include a lot of lawyers and accountants and economists and scientists and engineers and so forth who work for the different federal agencies. Now, why does this matter? Well, the principal officers are the top officials in agencies and departments, and they have to be appointed by the president and be subject to direct removal by the president. So the president, if it's a principal officer, the president has to be able to fire them. And if we try to create a statute that says the president can't do that, that's unconstitutional, right? And then inferior officers are lower level or mid-level officials. They still exercise discretion, right? And but they can either be appointed and removed by the president or others, and that's right in the Constitution, right? That so most of these inferior officers, by the way, are appointed and supervised by the president's principal officers, the agency directors. And then you have the regular agency employees, the lower level employees who are hired and fired, usually by the Human Resources Office at the agency. And they fall under the legal regime of the Pendleton Act and the Civil Service Reform Act that gives them some job security, protects them against retaliation for their political party affiliation and things like that. But also it strictly conditions promotions and pay grades on things like seniority and credentials and performance reviews. And so it's a little bit of a double-edged sword. And I do want to point out that even though I have black space on my screen between each of these categories and seem to have defined them nicely in theory, in real life, we still have a lot of cases where the Supreme Court disagrees even among themselves about whether someone is a principal officer or an inferior officer, like in this case, or whether it's an inferior officer or a regular agency employee, like one or two of the cases that have recently gone to the US Supreme Court. Okay, here's a review question to see if you're still with me and have been paying attention. What's an inferior officer for purposes of administrative law? Is it a mid-level official who may be appointed and removed by the president or some other official as Congress designates? Or are we talking about that this is somebody who's just inferior, an executive branch official whose performance is consistently poor? This is supposed to be a giveaway question to see if you've even been listening. And if you aren't sure about this, then you might have missed the whole point and need to rewatch the video. Okay, that concludes our lecture about Morrison v. Olson.